Thank you once again for joining us, and we will now convene the second panel of the conference, which focuses on the evolving regulatory environment for a marine carbon dioxide removal. I'm Will Burns. I'll chair the panel. I'm co-director of the Institute for Responsible Carbon Removal at American University and a professor at Northwestern University. I'm pleased to be joined by three excellent members of our community to speak on these topics. Sina McCrory, who is with the U.S. Environmental Protection Agency, Romany Webb with Columbia Law School's Sabin Center for Climate Change Law, and Harold Ginsky with the German Environment Agency. As was true with the first panel, we'll use a similar format where we will start with initial interventions by each of our speakers. At the end of each intervention, we will look to the Q&A box. If there's any specific questions for that speaker, we will address them then, and we'll give each of the other speakers an opportunity to ask any questions of that speaker before moving on to the next presentation. We've set aside a couple of hours for this panel, so we should have plenty of time for a robust conversation among the panelists as well as with the audience. And so with that, I will hand it over to Sina for her initial presentation.
Great, thanks very much, Will. I will bring up my slides here. Hey, all right, well, good morning or good afternoon or good evening, wherever you are. So my name is Sina McCrory. I'm here from the U.S. Environmental Protection Agency, where I work with the Marine Protection Permitting Program, which is the program that works to implement the Marine Protection Research and Sanctuaries Act, EPA. So I am going to start, with a very quick introduction to where the Marine Protection Research and Sanctuaries Act fits in with the London Convention and London Protocol. I know we have another speaker who will be focusing on that, so I'll breeze through that section. And then speak really quickly about regulation of MCDR under US federal statutes. But the bulk of my presentation will be about the permitting process under the Marine Protection Research and Sanctuaries Act. So when we're talking about marine CDR, marine carbon dioxide removal activities, we're talking about various different ocean-based processes designed to remove CO2 from the atmosphere and store it in the ocean in various forms. So some examples of marine CDR could be things like ocean fertilization, ocean alkalinity enhancement, where you're adding different types of alkaline materials to the ocean to stimulate that drawdown of carbon dioxide, or sinking of terrestrial or marine biomass into the deep ocean to store carbon. And there's various other approaches as well. So really quick intro to the London Convention and London Protocol. These are two international pollution prevention treaties that really work together to address the deliberate disposal at sea of wastes and other matter. The United States is a party to the convention and a signatory to the London Protocol. And in the United States, the requirements of the London Convention are implemented under a domestic statute, the Marine Protection Research and Sanctuaries Act, or MPRSA. So the MPRSA requires a permit for the transportation and disposition of material in the ocean unless excluded. And the statute uses the term dumping, where it's defined as a disposition of material, which is a broad term to encompass both disposal and non-disposal activities. And MPRSA applies in ocean waters, which start at the US baseline of the territorial seas, which is essentially the low water line on the beach and closing lines on mouths of rivers. and extends seaward from there. So again, I won't focus too much on this, but the London Convention and London Protocol internationally have been working since the early 2000s to establish a global and effective regulatory mechanism for ocean fertilization, which is the first one discussed, as well as other marine geoengineering activities that fall within scope of these treaties. So in the 2000s, the parties passed several different resolutions on ocean fertilization. And then in 2022, the parties identified 4 additional techniques as priorities for legal and technical analysis by these groups, including 2 marine CDR approaches, biomass sinking, and ocean alkalinity enhancement. There's some good information available on the International Maritime Organization's website, which is where this QR code will take you. But I will let Harold speak to this in more detail later. So domestically in the United States, the MPRSA and other domestic statutes regulate marine CDR activities. And depending on the specific activity, including the location, the type of activity, a permit may be needed to authorize that activity under the MPRSA or the Clean Water Act. So there's various different permit types under these, and some examples of the types of MCDR activities that would fall under those permitting schemes are listed here in the table on the right. There are other federal statutes and other agency policies, as well as local requirements that would apply to some of these activities. And for a lot of federal actions like funding or conducting or permitting a project, there are particular consultation requirements and other coordination requirements as part of that I'll get to a little bit more in detail. So at a really high level, this is the MPRSA's permitting process as described in our regulations. And generally this process would begin with the applicant developing their permit application with all the necessary information. And then once EPA receives a complete permit application, EPA would prepare a public notice describing the activity, would form a tentative determination on whether or not to issue a permit for the proposed activities, and would also provide a proposed permit or proposed permitting conditions at that time for public notice and comment. And then also during that time, there are various interagency and intergovernmental consultations and coordination activities that would take place. And we'll talk a little bit more about that. And then the agency uses the information gained during the public comment period and through consultations and other coordination actions to prepare a final determination on whether to issue a permit and if so, what the terms of that permit would be. So under MPRSA, there are several different permit categories that could be applicable to marine CDR activities. In this phase of kind of the research and development, research permits may generally be the most suitable permit type for marine CDR research activities, but in some cases, a general or a special permit may apply to some of the activities. MPRSA research permits are for permitting the disposition of material into the ocean as part of a research project when EPA determines that the scientific merit of the proposed project would outweigh the potential environmental or other damage that may result. So that's kind of a special aspect of research permits under MPRSA. And for research, the location of the research project would be assessed by EPA and would depend on kind of the nature of the activities and would include a robust consideration of potential impacts that are kind of location specific. There are various criteria that EPA uses to evaluate permit applications under MPRSA, and these are laid out in the regulations. But in general, they fall into 4 different categories of looking at the need to conduct the activity, And for research that would also play into the evaluation of the scientific merit and the scientific basis for the study, as well as the need to do the research in the ocean rather than in a lab, for example, or other land-based activity. We also consider the impacts to the marine environment, impacts to human health, as well as impacts to other uses of the ocean, impacts to fisheries, economic impacts, impacts to navigation, to name a few. So EPA considers a broad selection of criteria when evaluating the permit application, and in general, the assessment is to evaluate the need and whether the activity could result in unacceptable adverse impacts to human health, the marine environment, or other uses of the ocean. So I mentioned there's a public comment period that's included in the permitting process, but there's various ways that the public or potentially affected parties could engage in the public in the permitting process for MPRSA permits. So EPA provides public notice of permit applications and holds a public comment period of at least 30 days for proposed MPRSA permitting actions. And at that time, EPA would make available the actual permit, the application itself for review, as well as other permit-related documents, such as maybe a technical fact sheet, a proposed permit or proposed permit conditions, and other important information related to the proposed project. And EPA also shares information through websites, social media outlets, and may also hold public meetings or information sessions. So I mentioned there's interagency and intergovernmental coordination requirements for MPRSA permits. And in most cases, a lot of these are led by the federal agency. And most of these processes would be ongoing during the public comment period process, but may also be started prior to receipt of a complete application to start these coordination and communication early in the process. So some of the entities that EPA would notify would include other federal agencies, such as those responsible for protection of protected species or habitats under the Endangered Species Act, or management of fisheries, as well as safety and navigation. EPA also follows a policy for government-to-government consultation with tribes on MPRSA permitting actions. There's also coordination with states and territories regarding coastal zone policies and water quality management. And then there may also be some coordination with other countries or other international bodies, depending on the type of activity and the location. All right, and then MPRSA permits in general would kind of summarize the key details of the activity and may also describe other types of requirements necessary for protection of the marine environment or for reporting purposes. So, for example, conditions could include description and volume of the material that's allowed to be released into the ocean, the specific timing and location of where those activities are allowed to occur, the specific methods for transporting and releasing and controlling the release of those materials, as well as requirements for environmental monitoring or potential contingency actions that would be taken if necessary. And then there also would be reporting requirements to report for the permittee to report on the monitoring activities and operational outcomes of their project. So I will close out there, but I will note that we have this information from today, as well as additional information available on EPA's website. And I encourage folks to continue looking back at the website as we plan to continue adding more information there. So we do have information about, or more detailed information about the permitting process, as well as specific resources for potential permit applicants, and also information about any proposed permits and opportunities for public comment that may be available. So at this time, we get this question a lot. We've received only two complete permit applications for marine CDR activities under an MPRSA research permit. So you can see information about those two proposed permits that are up on our webpage. We also have a general email box to field inquiries. So we're happy to answer questions and happy to field any specific questions from folks about possible projects or the permitting process in general. So thanks. Pass it off to the next one.
Great. Great, Sina. Before we go on to the next one, as I said, I think we'll try to address any immediate questions folks have, and also engender a little discussion among the panelists. So first of all, among the panelists, any questions in terms of Sina's presentation or comments? Harold. Oh,
I don't think we can hear you, Harold.
not there yet. Okay. So we'll move on and let Harold check his technical issues. Anybody else? Um, while Harold sorts that out, I'll ask you an initial question. Could you generally explain the distinction and kind of the practical implications of the difference between a an application for a research permit under MPRSA and a non-research or a general permit, and what the differences would be in that context?
Yeah, sure. And we get this question a lot too. So I mean, I think the research permits have a little bit different a different use case than some of the other permit types under MPRSA. I also think in some ways they allow additional I guess flexibility for the types of activities that might be permitted. So I mean, a research permit's really designed for to allow researchers to go out and try and address and answer specific research questions, right? So it should be designed around, you have research questions and you design a study to answer those particular questions. And I think there's, with research permits, there's an understanding that there will be some things that are unknown, that there are some things that are uncertain, and that there are things that need to be answered. And what we would be looking at is that we understand that those questions really need to be answered in an ocean-based setting, that they can't be addressed in a lab study. And we also would carefully assess the potential impacts and really take a close look at kind of the scale of the activity. Is it just as big as it needs to be, and it's not bigger than it needs to be to really answer the research questions? Because there is an understanding that there is some uncertainty and some unknowns. So managing some of that is going to be particularly important for a research permit. Research permits are also for an 18-month period, so they're a shorter term permit than some of the other permit categories, where there might be more of a long-term management strategy that's needed. So for example, special permits would require the designation of a site in the ocean, which is a more, would require a more intense environmental, review of that location, and would require a long-term, site management and monitoring plan to be in place. Whereas research permits are designed for sort of the shorter term research-based studies.
Right. Thanks for that. Harold, you ready now? No, you're not. Yes, it is the vagaries of being in Zoom land. So, we'll come back to you, Harold. You keep checking on that. And uh, do you have any immediate questions, Romany?
I think that was a really interesting presentation, Sana. I'm interested to hear, perhaps we could have a conversation after my presentation, because I want to dig into a little bit more the public consultation requirements that go into the permitting process, and also the intergovernmental consultation that you talked about. So maybe we could revisit that topic in the future in a few minutes, Will. But also, Sana, I'm very interested in the question that was raised in the Q&A about, you mentioned that, you know, the US is a party to the London Convention and a signatory, but not a full party to the London Protocol. How does that affect the way that you all think about MCDR, especially given that a lot of the recent activity, you know, the amendment and the resolutions and things that have been happening at the federal level, at the international level, sorry, have been happening under the London Protocol?
Yeah, I saw that in the chat as well. So this is probably more of a question for a State Department that kind of watches our international engagements and what all these mean. But at least from where I sit, I understand that as a signatory, but you know, we haven't ratified, but we have signed the protocol. In general, that would mean that the US can't take any action to you know, directly go against the protocol in sort of plain terms. And also, I mean, the MPRSA and under domestic, you know, the domestic statute that implements the requirements of the London Convention is a little bit no, it's a little bit broader than the convention actually, and in practice, there's a lot of parts of the protocol that are already implemented under MPRSA domestically. So in practice, we follow a lot of the kind of conventions of the protocol.
Okay. All right. So I will, Harold? No, you are still not there. I'm going to move to some audience questions then. First one is taking the example of a temporary non-moored device to attract fish. Does this need a permit under MPRSA?
I am probably not the expert to talk about fads, so I may need to pass on that one.
I thought that you
Let's
might.
see. Yeah. Oh, I see one
Uh,
about water quality standards. Does EPA have water quality standards identified that are needed to safeguard ecosystems? And the question is also about kind of seawater carbonate chemistry and things like that. So yes, there are water quality standards that are established that EPA has that would apply in sort of state managed waters, are generally where water quality standards would apply. There's also water quality criteria that are also available on EPA's website that have sort of broader applicability, I guess. There are ones that apply to pH, I believe, for marine environments, though there may not be ones for, you know, carbonate ions. Carbonate ions are one of the most abundant components of seawater everywhere. So I don't think there is a criteria for that one in particular.
okay. If a ship discharged pH adjusted water as a byproduct of normal operations, would that need a permit?
Again, I think as a, you know, coming from regulatory program, the specifics matter. So I think if there's a specific question that folks might have, I'm happy to, if you want to send an email, happy to answer questions about specific projects.
Okay. How do you judge scientific merit and weigh it against potential environmental damage?
Yeah, so we have various criteria in our regulations that that look at the different aspects of kind of the need, the scientific merit aspect, as well as the potential categories of, you know, damage to the environment or human health or other ocean uses. And EPA does sort of a holistic assessment of those things to really try to look at as broad as we can the different aspects of those to make a judgment. And I mean, I think this is really where kind of the public engagement and consultation process comes in as well. EPA forms their tentative decision based off of that kind of assessment to show, what our assessment of the scientific merit and the potential adverse impacts are. But then, I think that's where the public, interested, entities, as well as other agencies through the processes that are established would have an opportunity to weigh in. And we do really take the comments that we receive seriously, and those would help us form a final determination on whether to issue the permit, as well as whether to change permit conditions, or if the location is people tell us other information about why this location is not a good location, or there was some aspect that we didn't fully analyze that they think is really important and crucial to consider in that assessment.
Great. Harold, I heard a sound from your side, so I think you might be ready to go.
Can you hear me now? Ah, that feels better, if I may say so. It's even more easier than for my presentation. Okay, Sina, many thanks for your presentation. I would like to compare the German situation a bit with the US situation. In Germany, we have actually universities publicly funded doing the research, but I think the situation in the US is quite different. So maybe you can also talk a bit about the applicants for marine geoengineering research, because that may make a difference also from the perspective of whether or not to permit a project. Thanks.
Yeah, so I mean, we have folks from academia, from other agencies, from private industry. I mean, we don't have specific requirements for who the applicant is. We just have the kind of the same set of permit application requirements that would apply for any entity that's interested in a permit.
Okay. All right. We
May
are
I,
going.
may I add an information for you here? For in Germany, the situation is if we have a private institution asking for permission, they would have to pay a permission fee, whereas the universities, the public university, they do not have to pay this fee because they are relieved from this burden, if you may say so.
Okay. We are going to then move to our second speaker, which is Romany Webb from the Sabin Center. Romany?
Yeah, thanks, Will. Thanks for the introduction, and thanks to you and the team at the Institute for putting together this event and giving me the opportunity to participate. So as Will said, my name is Romany Webb. I'm the Deputy Director of the Sabin Center for Climate Change Law at Columbia Law School. For those of you who may not be familiar with the Sabin Center, we are an academic think tank that works to develop innovative legal tools to combat the climate crisis and advance climate justice. We have, for the past 8, nearly 9 years, had a program of work focused specifically on what we call carbon management and negative emissions technologies. And as part of that, we work on legal issues associated with sort of more traditional point source carbon capture and storage. We also work on atmospheric carbon dioxide removal, both land-based and ocean or marine approaches. And we do quite a bit of work on atmospheric methane removal. Today, I was going to talk a bit about some work we've been doing on the role of different stakeholder groups in decision-making around MCDR. Share my slides here. There we go. So we just heard from Sina about these various federal regimes for permitting and otherwise regulating MCDR activities. And those federal regimes serve a really important purpose. They provide an opportunity for federal actors like the Environmental Protection Agency to review projects before they move forward and to ensure really that they are safe and scientifically valid. And that is really a vital function that the federal environmental agency should play. But it's also important that non-federal actors are involved in and can meaningfully participate in decisions about whether, when, where, and how MCDR activities take place. And when I talk about non-federal actors here, I'm really using that term broadly to refer to, among others, Native American tribes, states, territories, local governments, local communities, and others who may be interested in or impacted by MCDR activities. And so I want to talk today a bit about why it's important to involve those non-federal actors in decision-making and how that might be achieved. And in particular, I want to focus on the impact that different legal structures have on the extent, nature, and form of engagement, and how different legal structures can be used to sort of promote and facilitate engagement. First, though, I'd like to provide a little bit of context for the discussion, because I'm talking about engagement and participation in decision-making specifically around MCDR. But that's just one piece of a much larger conversation that's been happening in the climate space. We've seen this really renewed focus over the last few years on engagement and participation across the climate space. And that's been driven in no small part by the Biden administration, which has had a real focus on advancing environmental justice. And so, as some of you may know, in April last year, President Biden signed Executive Order 14096 on revitalizing our nation's commitment to environmental justice. And if you haven't looked at this executive order, I would encourage you to do so, and do so relatively soon, because it will likely be revoked come January. But for now, at least, it says that all people should be afforded the opportunity to meaningfully participate in agency decision-making processes that affect the health of their community or the environment, and the federal government must continue to remove barriers to the meaningful involvement of the public in decision-making. In addition to encouraging this sort of public engagement, the executive order also really emphasizes the need for federal agencies to consult and engage with tribal nations and to coordinate with state and local governments. And the executive order directs federal agencies to take various steps to advance these goals, including things like improving information sharing, removing barriers to participation, and building capacity within tribes and states and other groups to really meaningfully participate in these processes. Now, to their credit, the federal agencies that oversee or are otherwise involved in the MCDR space have taken a number of steps to really advance these administration-wide goals around engagement and participation. And you see that in many places, but I think it came through particularly clearly in the final report of the Fast Track Action Committee on MCDR, which was released last week. There is a strong emphasis in the report on involving diverse groups in MCDR research. And the report talks, for example, about the need for inclusive, effective, and meaningful participation and engagement. It states that communities and diverse sectors should be engaged early and throughout the research process, and that the federal government should promote strong collaborations and connections across different sectors. So why this focus on engagement and participation in this space in particular? Well, as I said before, it is important to advance environmental justice goals, which have been a key focus of the Biden administration. The federal government defines environmental justice as the idea that all people should be able to engage with decisions that impact their lives. So if federal agencies want to ensure just outcomes, they must engage broadly when making decisions about MCDR and other topics. But engagement isn't just sort of the right thing to do. It also has lots of other benefits. And so we've seen across the climate space and beyond it, involving diverse groups with diverse expertise and perspectives in the design and execution of projects results in better projects. So there was a recent report by the Office of Information and Regulatory Affairs within the White House on broadening public participation and community engagement in government decision-making. And that report noted that Participation and engagement can help agencies better understand problems and consider all facets of potential solutions. And this is, I would argue, especially important in the context of MCDR activities, because those activities implicate diverse bodies of knowledge, and a diverse range of actors will have information and expertise that can help inform the design and execution of MCDR projects. So, for example, whilst a federal agency, like the Environmental Protection Agency, might ultimately be responsible for approving an MCDR project, for example, under the IRCR, tribes, states, and local governments may oversee other coastal or ocean-based activities and may have knowledge and experience that could help inform the federal agency's assessment of MCDR projects. Similarly, since those projects could have a range of impacts on a range of different groups, broad engagement with coastal communities, with other ocean users and similar groups can ensure that a federal agency that's responsible for approving an MCDR project considers all aspects of that project and the full range of benefits and risks it might present. Broad engagement can also be really important to help build trust and avoid or at least reduce opposition to projects. And we've seen this become an increasing issue in other sort of adjacent sectors where projects have been halted or significantly delayed due to local opposition, and often underlying that local opposition is a concern that local communities or local governments or others were not adequately engaged with and do not have the information that they need to fully assess and evaluate these projects. So, if we accept that broad engagement is useful and valuable, how do we achieve it? For me as a lawyer, I'm interested in thinking about how we can use legal structures to advance engagement and participation. And so Sena noted that MCDR activities may be subject to various federal laws, including but not limited to the Marine Protection Research and Sanctuaries Act, the Clean Water Act, the Rivers and Harbors Act, and others. Each of those laws impose permitting requirements through which federal agencies review proposed projects and decide whether they should go ahead. And so I want to spend a couple of minutes now thinking about whether and how non-federal actors can participate in those permitting processes. And Sena set this up really nicely. There are, I want to emphasize, some important differences between the different federal permitting regime, but they all include mechanisms for engagement and participation by non-federal actors. So this flowchart shows the basic process that's followed by the US Army Corps of Engineers when it's permitting projects under Section 404 of the Clean Water Act and Section 10 of the Rivers and Harbors Act. I know the text is small and it's probably difficult to read, but hopefully you can tell from this that there are within both of these regimes and also within the MPRSA regime, multiple opportunities for sort of public engagement. There is a real emphasis in all of the regimes on engagement with states, and there are specific requirements for notification of and consultation with states. There are also requirements for public notices. There are mechanisms through which agencies can hold public hearings, and there's a process by which agencies accept written comments from the public and others on proposed projects. This sort of engagement is really important and valuable, but it is far from perfect. One thing is that for the most part, the engagement comes quite late in the process. So Sena mentioned that in some cases, interagency consultation can occur before a permit application is filed with EPA, and that's really positive, I think. But for the most part, the public engagement processes don't happen until a federal agency has received and is considering a permit application. And by that time, the specifics of the project are largely set. So ideally, the engagement would be happening much earlier in the process at a time when members of the public and others can actually inform and influence the design of projects. Now, of course, many would say, well, that's yes, developers should be doing early engagement with members of the public and others, but that doesn't need to be part of the federal regulatory framework. And I think we have seen some really good examples of developers voluntarily and effectively doing early engagement. Unfortunately, we've also seen examples of that not occurring and that having really problematic consequences. So we may want to look at integrating this into federal permitting processes to ensure that it occurs. And there is precedent for doing that. There are other federal permitting programs that require early engagement before permit applications are filed. And so one example is the permitting of hazardous waste facilities under the Resource Conservation and Recovery Act, RCRA. Regulations issued under RCRA require that before applying for a permit, the applicant must hold a public meeting, accept public comments, and answer public questions. And then the applicant has to provide information about that public engagement as part of its application to the federal agency, and there is additional public engagement as part of that process. So this is just one model, likely of many, that could be looked at for use in the MCDR context. In addition to addressing the timing issue, we also need to address other sort of practical barriers to effective participation in these federal permitting processes. And there are several. One is just the time it takes for engagement and participation in these federal permitting processes. Another relates to the sort of knowledge and skills that are required to effectively participate. There was a study by the study I mentioned by OIRA, the Office of Information and Regulatory Affairs, noted that in order to effectively participate in federal processes, people require specialized knowledge and skills. And in the MCDR context, they need to not only understand the federal permitting process, but also be able to understand and evaluate the MCDR activity that's proposed. And that can be really difficult, not just for members of the public, but also for tribes, for local governments, for states, etc. You know, MCDR is a new field, and many groups may lack the knowledge and the expertise that's required to really understand and evaluate proposed projects. In other contexts, federal agencies have established projects to provide sort of technical assistance and to build capacity within states and tribes and other groups so that they can more effectively participate in permitting processes. And we've seen that, for example, under the Clean Air Act and other federal regimes. So again, there's likely models that we can draw from to improve the process for MCDR projects. And again, to the credit of federal agencies, the FTAC report does recognize the importance of this, and it does lay out specific recommendations for federal agencies to work with states and tribes and others to build capacity. And that's what you see here. At the Sabin Center, we've also been thinking about, beyond this sort of participation in federal permitting regimes, are there opportunities for non-federal actors, especially states, to play a larger role in directly regulating MCDR activities? There are some important limits on the ability of states to regulate MCDR. One arises from the relatively limited offshore jurisdiction of states. So as many of you will know, consistent with international law, the US has claimed jurisdiction over offshore areas extending out 200 nautical miles from shore. Jurisdiction over that sort of 200 nautical mile zone is shared among the federal government and the coastal states. And generally speaking, the coastal states have primary jurisdiction over a relatively narrow band of water near to the coast, within 3 nautical miles of the coast. And in parts of the Gulf of Mexico, state jurisdiction extends a bit further, but still it's only to 9 nautical miles from the coast. So states have primary authority over this sort of relatively narrow band of ocean waters and can regulate activities within those areas. But there is also some federal regulation of activities within state waters. And that creates the potential for overlapping or even conflicting federal and state law. And where, for the lawyers listening, you will know that where state law conflicts with federal law prevails. That is a fundamental principle of US constitutional law. The Supremacy Clause of the Constitution says that federal law is the supreme law of the land, and the courts have interpreted that language to create this doctrine of preemption, whereby federal law supersedes state law. So given that, if we have these federal laws that apply to MCDR, like the Marine Protection Research and Sanctuaries Act and the Clean Water Act, that raises the question, like, is there actually any room left for state regulation? And that's something that we've been doing a lot of thinking about at the Sabin Center. We have a new report that will come out in just a couple of weeks that I co-authored with two of my colleagues, Ashwin Murthy and Corey Silverman-Rawati, that looks specifically at the extent of state authority to regulate ocean alkalinity enhancement. To give you guys a sneak peek, we conclude that there are opportunities for state regulation of MCDR, of ocean alkalinity enhancement specifically. Each of the federal laws that apply to MCDR activities do leave space for some state regulation, although there are limits on exactly what that may look like. But this sort of state regulation could actually be very valuable in terms of giving states a larger role in decision-making around sort of when and how and where MCDR activities take place. It could, though, also result in some issues. There is, among other things, the potential for duplication of effort, whereby the federal government and states are performing overlapping functions that add time, cost, and complexity to the project development and review process. And so it will be really important for federal agencies and coastal states to closely coordinate. And again, that's something that's recognized in the FTAC report as being really important. I think I'm almost out of time here, but I do want to just touch on one other topic. So we've talked about the opportunities for non-federal actors to participate in the federal permitting process. I've talked about the potential for states playing a larger role in sort of directly regulating these activities. What about local communities? We have seen in the sort of broader climate space a real focus on an attempt to use benefit sharing mechanisms to involve local communities in climate related projects. And so one of the mechanisms that we've seen used are what are called community benefits plans, or CBPs. This is something that the Federal Department of Energy is requiring applicants for federal funding to submit with their application a community benefits plan that outlines how that applicant will engage with the community and will hopefully positively impact the community. And if a funding application that includes one of these CBPs is approved, then compliance with the plan becomes a condition of the funding agreement and is enforceable by the Department of Energy. The Department of Energy has also said that it hopes that developers will go one step further and enter into binding community benefits agreements, which are agreements between developers and local communities, under which the developer agrees to engage with and provide benefits to that community. This is becoming increasingly common in other climate-related fields, and we have actually at the Sabin Center put together a database of example community benefits agreements from the renewable energy sector and a variety of other sectors. And can be the learnings from some of those other sectors is that these agreements can be a really effective way of involving local communities and other stakeholder groups in the development and design of projects so that they can play a meaningful role in the process. Okay, I'm going to leave it there, Will, and we'll hand back to you.
All right. Thank you so much, Romany. And we can start off with some questions from the other panelists, if any, for Romany on the presentation. Sena or Harold, do you have any initial questions? Okay. All right, Romany, I'll put you on the spot then. Uh, Public engagement, as you know, is an issue that I'm really interested in, and I thought I really agree with you that there's a need for a lot more front-ended sort of engagement, and I think a lot of times developers and maybe the government is leery of doing so because it can slow down projects, but then I think paradoxically it often dooms projects. But either way. Uh, let's assume we have a project that achieves regulatory permitting, but it's very clear that the public in any given area opposes that project. Do you think that project should be allowed to proceed, or is there some broader conception of social license to operate that we should be trying to incorporate into our decision-making process when it comes to MCDR?
Yeah, I mean, I do think it depends on the specifics of the project and the nature of the opposition. I do not think it is practical in the broader sort of climate landscape to have a situation where one individual can have a right of veto over projects. And so I think we should be upfront about that. But I also think that mere sign-off from a federal agency is not necessarily sufficient. And we have seen that time and again in the other projects, some of which were highlighted in those news clips in the slides. So I do think we need to somehow build in this concept of social license to operate. Thinking about how that intersects with the regulatory regime, I think is really important. And ideally, we would sort of integrate them on the front end so that we don't end up in a situation like you're describing, Will. But I do think there's certainly more work to be done. And this is like an issue, not just in the CDR space, but in my view, across the sort of climate infrastructure space.
Have you seen any discussion of that in the context of MCDR to date?
I mean, I see it in some of the great work that Sarah Nawaz at the Institute does, in some of her work around sort of democratic governance of MCDR activities. I see elements of that, but I do not think that the sector and the people that sort of work adjacent to it, like myself, have really thought deeply about it and come up with sort of viable solutions for integrating social license with regulatory approval.
Harold.
Thanks, Romani. I also want to add, in this case, a bit of German experience. About 10 years ago, we thought we can start carbon capture and storage on land in Germany, but there was a lot of strong opposition by local communities or by NGOs, civil society organizations. And the core reason for that was that nobody thought about the benefits in these spots where the carbon capture and storage, the storage should take place. So that there was no discussion on the benefits for the local community. And to get only the waste dumped underneath the houses is not a strong argument for support. So I think this is it's an important point. And we made this experience. So in Germany, it's actually the situation now concerning carbon capture and storage is that we want to avoid carbon capture and storage on land, and we go more for the oceans because that's easier to communicate. That's the political consequence out of this. I mean, Germany is very densely populated, so it's a different situation than in the US. So there, if you store something somewhere, there will be always population around. So this is a bit also a difference.
Yeah,
Thanks.
I mean, I think we have seen the same discussion in the US around subsea bed carbon storage. And your point about, failure to fully appreciate the benefits that those projects or other sort of climate infrastructure development can have is one that we have seen play out here too. There is very much a focus on the negative impacts that those projects have, which are significant and need to be grappled with, but less focus on the benefits. And the focus that we've seen on using benefit sharing mechanisms in the context of these projects is really designed to address that, I think.
We have an audience question for you, Romany. Getting community benefit agreements in place prior to the project getting launched would be enough to end most IP-based projects that need a rather high degree of confidentiality. Are there any exceptions that reduce this rather heavy regulatory burden?
Well, I'm not sure that I fully agree with the premise of the question, though I would be interested to talk more with the person who posed it about why they say it would end IP-based projects. Because actually, I think you could structure benefit sharing arrangements in a way that didn't really require disclosure of IP or other confidential information. I will also say that currently, to the extent that use of benefit sharing mechanisms is a condition of funding, in the US, it's a requirement that developers enter into or develop community benefits plans, which are much softer than community benefits agreements, and require arguably even less sharing of information. So I think that is one way that that's been addressed in the US context.
All right, thanks for that, Romany. All right, with that, we will move on to our next presentation by Harold Ginsky. Harold, it's all yours.
Okay, can you see my slides now? Yeah, you can. Okay.
Yes.
Okay,
you're not in presenter mode yet, though, Harold.
Yeah, I try to. Hopefully, I can do it, but you can read it, huh? I hope you can wait. Tricky here.
Yeah, my German's not good enough to know which one of those menu items are the ones. I think it's the build share.
Yeah, but I think it should be fine. Now you can see it and it's large enough to understand. Okay, colleagues. First, I want to thanks for the invitation. I would provide a bit of information about my entity I'm working with. It's the German Environment Agency. Our core mandate is to provide science-based policy advice to our ministry. So we are a consultative board, and we provide this science-based policy advice on an interdisciplinary and sometimes also on a transdisciplinary manner. To my professional background, I'm an environmental lawyer, and for our context here, I have been a member of the German delegations to London Protocol, London Convention, almost for I just do not dare to say it, almost for 20 years, so for a very long time. I have been member to the German delegation to these regimes. So my topic today is to inform you about London Protocol and how it govern marine geoengineering now and maybe in future. Concerning London Convention and London Protocol, a bit of background information. The core mandate of these two international treaties is first the prohibition of incineration, and second, to deal with dumping of waste and other matter into the ocean. So this is the core mandate. But what is not addressed by these two instruments is first waste disposal from abstraction industries. So oil, gas, and mineral resources are not within the mandate of these two instruments. The competence for these abstraction industries are with the international seabed authorities and with regional organizations. Secondly, what is not addressed by London Protocol and London Convention is waste disposal from normal shipping operations, and the competence here is with the International Maritime Organization. Sometimes the words convention and protocol are misleading the interpretation, what is meant really. So I would like to highlight that London Protocol is an international treaty for its own. It's another treaty next to the convention, and it was adopted later. Of course, it was adopted 1996, whereas the convention was adopted 1972. And the London Protocol is the more modern, the more stringent, and more up-to-date, because inter alia it has addressed geoengineering issues. Nevertheless, unfortunately, London Convention has much more contracting parties, about 890, whereas London Protocol has now 55 contracting parties only. So this is I will come back to this aspect later in my presentation. But I mean, London Convention, London Protocol, they have created the term two instruments, one family. So this is very interlinked, the work. And in fact, many London Convention parties, like the US, for example, or accept London Protocol standards informally or even by national law. So actually you can't, it's too easy to say London Protocol standards, legal standards are only accepted and implemented by 50 contracting parties. It's not the reality. I want to highlight that London Protocol and Convention have been very effective concerning the reduction of dumping of waste and other materials. So this is a success story in fact. And if you want to find a bit more of information, I added here the web link. So my topic today is not to talk about London Convention and Protocol in general, but about the governance of marine geoengineering by London Protocol and Convention. And I titled this slide, "What is already there?" So what is already in place? What do we have? Actually, these are mainly four, let's say, instruments of set of regulations. First, the provisions of London Protocol and Convention for themselves. So they have, as I said, they deal with the introduction of matter. And as from several marine geoengineering, they include introduction of matter. These provisions are directly applicable first. Secondly, London Protocol has come up with amendments concerning carbon sequestration in subseabed geological formations in 2006 and 2009. The 2006 amendment established a legal framework for both research and deployment activities for carbon sequestration in subseabed geological formations. So they address both. And then we had a little issue because London Protocol prohibits the export of waste to other states. And this was lifted in a way by the 2009 amendment, but this amendment is not yet in force. So 2022 or 2021, I'm not exactly sure now, the London Protocol parties established a system of provisional application of the 2009 amendment to lift the ban. And if two parties decide that they would like to provisionally apply this amendment, they can do it amongst themselves, and thereby they lift the international ban of exporting CO2 to be sequestrated in another state, in the oceans of another state. So that's the second piece. The third piece are the two resolutions on ocean fertilization. In 2008, it is a resolution. The resolution prohibited deployment of, in a way. So you can talk about the legal details, but I make it quite rough and understandable. So there is a sort of prohibition of deployment of ocean fertilization activities, and in addition, a requirement to control legitimate scientific research activities concerning ocean fertilization. And by the 2010 resolution, a specific assessment tool was adopted, the Ocean Fertilization Assessment Framework. The states, the contracting parties decided that states should use this assessment framework in order to decide whether a project is legitimate scientific research or this deployment, and thereby then not to be permitted. These two resolutions have been regarded as not legally binding. So in the period from 2008 to 2013, contracting parties under London Protocol worked hard on an amendment on marine geoengineering. This amendment is legally binding in nature, although it is not yet enforced because there are not sufficient ratifications, but I will talk about this later. It addresses for the time being only ocean fertilization, but it's open to add more techniques. There's an annex 4 it's called. There are the marine geoengineering techniques are mentioned, which are controlled by the amendment, but there's the opportunity to add more techniques. And if you want to get a bit more detailed information about London Protocol work on marine geoengineering, you should click this this webpage. So now a bit more in detail concerning the research, marine geoengineering research. I said this is it's addressed by the Ocean Fertilization Assessment Framework and then by Annex 5 of the amendment of 2013. And I think what is really important that both instruments, the assessment framework and Annex 5, established criteria to differentiate research and deployment. And I think that these criteria are quite, actually they're novel in international law, first of all. And secondly, they are also appropriate. So in order to be a research project, you need to show that your project will add to the scientific knowledge, that you use an accepted methodology, that you have undertaken a peer review. It needs to be, evidence needs to be provided that the research contents and design are not influenced by economic interests. And there's a requirement that the results of the project are published afterwards. So this is the set of criteria states should use in order to decide whether a project is research or its deployment. A second bit of this Annex 5 is a structured environmental impact assessment. So this is it's not called an environmental impact assessment, but it is in fact an environmental impact assessment. And there's a third element which is also important. The Annex requires certain consultation procedures. So this was by Romani a minute ago. So there's a need to consult all potentially affected international regimes or potentially affected states, and the operators have to also to organize a consultation process. And moreover, there's a provision that international independent experts should be involved in order to come to objectivity and transparency. So this is a mechanism in order to achieve these two goals, objectivity and transparency. And finally, the amendment of 2013 requires a permission by a competent authority of the contracting state. So what I would like to talk about is what are the purpose of this regulatory approach of London Protocol concerning research. You may say that this is only about protection of the marine environment, but I think it's actually much more. Actually, the purpose, there are several purposes of course, but I would say there are three main purposes of this regulatory approach. First, and this is crucial in my view, is to provide reliable scientific information to enable an informed decision on future deployment. So what we do not want, at least this is the view of Germany, what we do not want is fake, I call it quite clearly, fake marine geoengineering. So an activity which does not help to mitigate climate change. So, and therefore we need really good scientific information. And this regulatory approach ensures that we get this information. Secondly, of course, it also the regulatory approach with the environmental impact assessment is also about to ensure the protection of the marine environment. And third, I mean, such an approach also establish a level playing field and enable international cooperation. And one mechanism are the reporting obligations under the London Protocol to ensure this international cooperation. In 2022 and 2023, the contracting parties of both instruments, and this is the important London Convention and Protocol, adopted statements. Statements, I put it in the end of the slide, are not legally binding, but they are sort of an expression of common understanding and will of the contracting parties of both instruments. And the core agreements in these two statements are the following. First, they refer to 4 emerging new MGE techniques: enhancements of alkalinity, biomass sinking, marine cloud brightening, and reflective particles on the ocean surface. So you see that marine geoengineering encompasses both CDR and SRM techniques. So this is the take here. Second, there was an agreement that these 4 techniques could put risk to the environment, so they are risky. The contracting parties also agreed that there's a need for regulation. And in 2023, it's not correct here, it's 2023, the contracting parties decided that they should defer from other activities than legitimate scientific research. So this is sort of an agreement that the time is not mature for deployment techniques deployment project with regard to these 4 techniques. And there was an agreement amongst the contracting parties to request states to use the existing assessment frameworks inter alia Annex 5. So latest development, the London Convention, London Protocol governing bodies took place the last week of October this year. And there were several outcomes. You see the green box, I have included the outcomes here. First, the contracting parties of both instruments decided to establish a specific intersession correspondence group on the promotion of ratifications of the London Protocol itself and its amendment, as all amendments, the carbon capture and storage amendments, and also the marine geoengineering amendment of 2013. Then the contracting parties also agreed, again, a statement on marine geoengineering. In this statement, the future work for the next year was outlined, and thereby London Protocol and London Convention stated that there is a role of these 2 instruments with regard to marine geoengineering. Concerning the work on marine geoengineering, 2, again, intersession correspondence group were established, one scientific, one legal, and these 2 groups should work on more precise definitions of the new techniques. They should work on specific assessment tools for each of the techniques, and they should also consider how to add these 4 techniques to the Annex 4 of the 2013 amendment. The box on the right side, this is about challenges for LP, and I mean this is I differentiate here the near future and the midterm future. First of all, it's a legal question. If there will be assessment tools for the 4 techniques, and if there's an agreement amongst the contracting parties that these assessment tools are sort of best practices, this may have legal implications, because if they are accepted as best practices according to the advisory opinion of ITLOS, or was it this year? I think it was this year. on climate and ocean regimes, this would have an impact on the compliance with the due diligence obligation. So this could, although the legal interesting point is here is that although the assessment tools are in itself not legally binding, this could have a legal implication. So this is the interesting point here. Midterm future challenges for LP, we need to deal with what was called at the last governing bodies meeting, the perspective of the receiving countries. Several states of the global south called themselves receiving countries. That means we need to take into account also their perspective when we talk about marine geoengineering. And Romani, you talked about the involvement of non-federal actors, so you can even go beyond, and you can talk about the involvement of perspectives and needs of maybe communities and whatsoever in other states. That's the first. Second, it's in our view, German view, but it's also my view. London Protocol is not so much about an assessment tool for the climate efficiency of marine geoengineering techniques, but who should deal with that? Because as I said during my presentation, it's very much required that we are sure that these techniques really help. If we only spend money and only money is earned, this will not help us to deal with climate change. So this is the second. Then third, is London Protocol and London Convention, is there a legal basis to establish also area-based management tools? And the fourth is the concept of prohibiting MGE deployment. Is this too strict? And do we need also to think about a way forward for techniques which have shown that they are efficient concerning climate mitigation? So we need to also think about that. This is a challenge. So I have only 3 more slides. I hope I'm not too late. Is it okay? Will, I'm in time? Okay. This is I heard this in academic papers. I read that London Protocol and Convention are ignorant concerning potential benefits of MGE techniques. And Roman, you have also addressed this point in one of your papers. I think this is, if you read the provision itself only, or if you read the provision, you can come up with such an understanding. But being a member of the German delegation and following the intervention of other delegations, I think this is not the reality. Actually, London Protocol and Convention are based on the policies of the contracting parties. So the delegations come, the interventions are based on the internal policies of all delegations. And so Germany is not going to say this within London Protocol and something else under UNFCCC. We have one policy which we follow, and this policy is based on a cost-benefit analysis of these techniques. And this is actually the case of everybody. So my view is that the benefits are always part of the discussions under London Protocol. And two more arguments. If you look at the different regulations of CCS and ocean fertilization, this is based, of course, also on the potential negative effects on the marine environment, but it's also based on the understanding that carbon capture and storage could be beneficial for mitigating climate change, whereas this was not the case for ocean fertilization. So the benefits are always part of the discussion, and I leave it here. We can discuss it more in detail. 2 more slides. First, weaknesses and strengths of London Protocol. Weakness, London Protocol has only 45. This is also not correct. It's an old figure. It's 45 contracting parties, and we need to increase this number, or there's a need to increase the number. Second weakness is the low number of ratifications for the amendments. And sometimes there's also a weakness, I would say, that the London Protocol and Convention system has to comply with the IMO rules of procedure, which are often quite formalistic and quite bureaucratic. So this is not the quickest way of doing things. The strength, first, I think that the London Protocol and Convention are so effective because they have come up with so many decisions in such a short period of time, is as both instruments has a very focused mandate. This is not as broad as BBNJ or as CBD talking about biodiversity, which is actually everything, but it's a focused mandate to protect the marine environment and from different activities. Second strength is the growing involvement of the Global South. So the next chairs of the governing bodies will be 3 persons from the Global South, which is very great. We have a chair from Morocco, 1 from Peru, and 1 from South Africa. So this is a new development, which is great. And third strength is it's, as I said, very effective, flexible to respond to challenges, and there's a high level of engagement of parties. So this is my last slide. Core messages. I start on the left side. On a higher level. So first, it's very effective. I said that, but potential benefits are always part of the decision making. The research regulation ensures reliable scientific information to take in to enable informed decisions. In my view, and I have published a paper on that together with Professor Oschlies from Geomar. This could be a blueprint for for the regulation of other climate engineering techniques. The box in blue. There's work ongoing, the assessment tools and promotion of London Protocol work. We need the ratifications as a core weakness has to be overcome, and then new regulatory challenges. And we need really to think about how we can ensure that the MGE techniques are efficient in order to dealing with climate change. Thanks for your attention. Thank you.
All right. Thank you so much, Harold. So let's start off with any questions from the other panelists.
I had a couple of questions, Will.
Okay.
One is about so you mentioned, Harold, the fact that the parties have adopted an amendment on subsurface carbon storage that covers both research and deployment, and actually have taken a number of steps to facilitate subsurface carbon storage through the provisional application of the export amendment, for example. And it's quite marked the difference in treatment of that activity versus marine geoengineering activities, where we've seen a lot more concern, a lot more restrictions put in place, this real focus on sort of just moving ahead with certain research projects. And I wonder if you could say a few words about what you attribute that differential treatment to. Is it really just, you were making this point at the end about the benefits and the fact that subsurface carbon storage was seen as having greater benefits? Is that the explanation, or are there other factors at play that explain this sort of differential treatment of CCS, of subsurface carbon storage versus marine geoengineering?
So this is not easy to be answered because we need to talk about 5 techniques. They are not all the same. I mean, I would say for ocean fertilization, it was very clear. There was no conviction that this technique could be really beneficial to mitigate climate change. So that's clear. For the others, I would think it's not that clear. So we do not have we have not so much a common understanding here that there's no clarity on the benefits concerning mitigating climate change. I would say that there was a it was the understanding that it is premature to say whether they will be effective or not to mitigate climate change. So that this is the difference. Whereas for carbon sequestration, there was an understanding this could help to mitigate climate change. So this maybe I answer quite short, but maybe it's then easier to understand, and we have time for more questions. Thanks.
Can I ask a quick follow-up, Will? So my other question is really about, you mentioned there that we're talking about like 5 different techniques that are at different stages of development and involve different activities and have different risks. Could you say a little bit about why, in particular, the 4 marine geoengineering activities that are currently being looked at have been sort of lumped together, and does it make sense in your view to consider the CDR type approaches together with the SRM based approaches, even though, you know, those things serve different purposes in terms of mitigating climate change, or might be used in different ways to mitigate climate change? They have different benefits, they have different, or potential benefits, they have different risks. Could you say a little bit about that?
Romani, it sounds a bit like your question that there is already a final answer to these questions, and I think this is premature. This is the thinking behind all the decisions. We do not have sufficient information to decide whether or not these techniques could be helpful to mitigate climate change. So the contracting parties in 2023, they put a stop. In fact, it's not a legally binding stop, but they said, okay, defer from other activities than legitimate scientific research. That means it could be understood as a understanding that other activities should not be undertaken. But the reasoning for that is not that it is said they are not helpful. It's the reasoning is we do not know for now. We do not know for now. This is the argument. So this is the first bit. The second, you refer to SRM and CDR. I mean, this is actually not for me because I'm an environmental lawyer and not a science person. But having followed this discussion, I would think it's too simple to say SRM is in all cases more risky than CDR techniques. I would not say that. This is not I think it's not the understanding of the London Protocol parties, and it's not the status of the scientific knowledge. We don't know. I mean, carbon, the biomass sinking is probably a quite risky technique if you apply it in larger scales. Whereas, for example, I don't know. So I mean, concerning the SRM techniques, whether these are less or more risky, I cannot. For me, it's not to be answered. I mean, there are risks if you introduce micro bubbles on the surface of the ocean in larger amounts, then it's actually waste what you're bringing into the oceans, and this may have negative effects to the oceans, and so it's not clear what risks are involved concerning these techniques. Or I mean, the risk in itself are known, but the dimensions of the risk and the effects, this is not yet known, and it very much depends on the scale of the project and the activity in the end. Sina, you are also you are more the scientific person than me. If you want to add something, I mean, go ahead, please.
Yeah, I guess I was thinking.
Go ahead, Sid.
Sorry. Yeah, I was thinking about your question of, do we lump these all together or do we not? I mean, I think part of the discussion, the reason why it's been sort of framed that way by these treaty bodies is just part of the history of the discussion of where this came from, and like these groups don't exist in a vacuum, and so these techniques have been talked about for many years, and I went through a process of kind of bringing a list of some of these marine geoengineering type activities, bringing them to the bodies and asking them what are the priorities to consider to continue doing some legal and technical analysis on, And I think part of that, discussion was based off of what types of things are parties seeing in their, what types of activities are actually being considered right now. So kind of what are the priorities? But I think there's an understanding that each of them are different, and even within them, there might be subcategories of these various techniques that need to be considered separately because they're not all the same. And I think from a scientific standpoint, we're pretty aware that, things are different and there's different considerations for each of these.
So Harold, I want to push back a bit on your characterization of the regime considering risks and benefits, okay? And I want to couch that at the outset by saying that, if you've read any of my stuff, I have lots of serious questions about MCDR, right? But when I look at the language that from some of these resolutions, right? The language always seems to say we've looked at these approaches and there's some serious risks, right? There's risk to human health, there's risk to the environment and so forth, right? And in none of those did I see any recognition, but there could be some clear benefits, right? And outlining those, right? The emphasis has always been on the risks, right? And then when I look at the ITLOS decision, right, on climate change, right, we have hundreds of pages, right, that are outlining how climate change is potentially devastating to the marine environment, and that the parties have an affirmative obligation over and above what they're required to do under Paris to address said risks under UNCLOS, right? But then, tucked in there is one very short paragraph that says, well, some people are looking at marine geoengineering, but it has a lot of risks, and they reference the London Convention. And then they say, and under UNCLOS, right, if you're converting one form of pollution to another form of pollution, that's not permitted, and that the implication seems to be that if any pollution is generated from a marine geoengineering approach, it's conversion under UNCLOS, and thus it's not valid, right, or legal. Uh, where in any of that do you see an effort on the part of the parties to London to balance risks and benefits? And I'd add to that, there's the GAZAMP document, right? That where GAZAMP, which is a scientific body, right, that's supposed to inform all of this, specifically chiding the parties for not doing that. Do you think that the parties really have an inclination to look at risks versus benefits, and where in the language of any of the resolutions they've passed have they evinced that balancing approach?
The US is party to this not to London Protocol, but it's actually negotiating or discussing also the decision of London Protocol. I would assume that the US in itself has a clear vision and a clear understanding of both the benefits and the risks. And based on this, the US is making its intervention and is pushing the work of the London Protocol forward. So this is not only for London, not only for the US, but also for all delegations. So Germany has very much in mind which techniques how we deal with these techniques. If we would think that it's already we can also already take a decision to deploy certain of these MGE techniques. We would go for that. And it's the amendment allows that. The amendment actually is not about only the research activities. It's completely open also to regulate deployment activities of MGE techniques. So this is my first point. Second is if you look at the statement of 2007, it's quite a long time ago of ocean fertilization. The lacking knowledge concerning the mitigating effect of ocean fertilization was mentioned as one reason. So this is also where we took into account the benefits. Already, I was not around at that time, but the London contracting parties took into account the benefits. Third, concerning carbon capture and storage. same thing. It was decided this technique may be beneficial, and on this basis, the regime included both research and deployment. If you look at the resolutions of 2008 and 10, the IPCC, I'm quite sure, I'm not completely sure, but I think the decisions in this context of UNFCCC and IPCC were mentioned. Same goes for the statement of 2022 and 23. So these international regimes which build up also the policy views of the states are mentioned in these resolutions. So I think the benefits are mentioned, but I mean, well, we need to see. We talk about potential benefits. Nobody knows so far whether these 5 techniques could really help us to deal with climate change. We do not need to, it's very risky if we don't highlight this all the time. There is no clarity whether these techniques may be of help. So this is, I think we need to be clear on that. And yeah, I stop here. I can keep on. I think this regulatory approach makes a lot of sense. I mean, in the last in 2024, I don't know whether you have seen the statements. It's not yet out, but there in the first line, the potential benefits are mentioned. So this is we mentioned there might be potential benefits, but everybody knows we need. If one of these techniques would be effective, everybody would go for it. I mean, this is if one of these techniques would help us to mitigate climate change, of course, everybody would agree to do that.
All right. I'm going to move to questions that we have in this context. We probably have enough of those questions that may be what we close out with. I think we're just going to skip our last presentation because I want to get to these questions because I think there's a lot of interest in London, and if we have time, I'll circle back to some of the other questions for other speakers. First question is, how long does it take to apply for a research permit for an MGE project under the convention or the protocol?
This is a misunderstanding. The international provisions need to be implemented into national law, and then it's decided how long it takes. So this is
I
in
think
Germany.
a modified question would be how long in Germany, for example, does it take on average?
Actually, in Germany, Germans are sometimes quite strict. So we have come up with a legislation which prohibits, in fact, for the time being, all marine geoengineering activities, both research and deployment, except ocean fertilization. And there has not been any ocean fertilization research project in the last year. So there's no experience on that. We have but this is going to be changed. So we will open the legal framework for alkalinity enhancement, or I forgot that, upwelling and other techniques. So in future, in 2 years' time, I can answer your question, but not now.
I guess this might be a question also for me, as MPRSA implements the London Convention in the US, so we are the domestic permitting statute. So generally, our regulations do give certain timelines for things. So there's kind of a 30-day review timeline for an initial application, and then there's also, I don't have the exact words in front of me, but to the extent possible, the permitting kind of process, we aim to conclude that within 180 days. But again, that's sometimes contingent on some of the consultations and other requirements that need to be concluded. But that doesn't include the kind of application development phase, which can take some time for the applicant to assemble, a complete application that has all the necessary information as listed in the regulations. So I guess, but ballpark, that process could take a few months and would have some kind of back and forth between the agency and the applicant.
Let's see. Yeah. Go ahead, Sue.
I was going to say I could also jump in and answer. Another one that I saw come up in the Q&A was about the term of the research permit being 18 months and how would that impact monitoring for biodiversity or other kind of environmental impacts. So generally the monitoring activities could continue beyond that 18-month period, so long as there's no disposition of material that's happening outside of that term. And then research permits are also can be considered for renewal as well. So yeah, we understand there may be some monitoring that needs to continue to really understand the system.
Let's see if there's any other ones we've missed here in this context.
Could I also ask maybe both Sena and Harold because there is this misunderstanding that I hear all the time about there's a international permitting regime when actually it's domestic permitting regimes that flow from the international. Maybe you could both say a few words about what your respective domestic regimes apply to in terms of when a dumping project will be subject to the NPRSA versus when a dumping project will be subject to regulation under German domestic law. What are the sort of hooks that determine if EPA regulates here or if the German Environment Agency regulates or another country?
So at least under NPRSA, it would apply to activities that are under a U.S. flag vessel when the material is transported from the United States, for example, or if there's material that's transported into kind of U.S., into the territorial seas of the U.S. Those are some examples. But I think when there's a question of who would apply, I think that's when that international coordination aspect takes over. So I think when there's activities occurring in another in another state's waters within their exclusive economic zone, there'd certainly be a conversation that would take place of who would be the authority there. Harold, can you chime in too?
Yeah, it's our law is complicated. We have you can talk about the spatial scale of scope of application. The spatial scale is the internal waters, the coastal territorial sea, and the EEZ of Germany, but also the EEZs of other states and the high seas. So this is what is really excluded from our law is the territorial sea of other countries. This is not part of our regime. Concerning what is the trigger point, it's the flag of the ship, German flag, the loading of the stuff if it's loaded in German harbors, and there's a third category, but I forgot that. Sorry, because we do not have so many cases, as I said. Sorry, but it's actually really aligned. It's implementing the London Protocol's requirements for the entry points.
Yeah, and I guess another common point of confusion is whether we at EPA could issue a permit for something happening outside of in the US EEZ or even beyond the EEZ. And we can if one of those conditions applies, and in fact we've done that for emergency permit situations. We've issued permits offshore of Africa. So I mean it can apply in other places so long as you meet one of those conditions.
I mean, Romani, to add to this, for us, for example, when we had a case like this, if a German vessel is doing research on MGR techniques, not ocean fertilization, and this is conducted in an EEZ of another state, that was our law would apply, and this activity is just prohibited under our law because due to the spatial scope of application and the system if this is a German vessel is used. So it's quite strict. It's quite strict and complicated. Yeah.
But as both Sena and Harold mentioned, these domestic permitting regimes can apply even if you're operating on the high seas. I think that is also a very common point of misunderstanding.
Hmm.
There's a couple of other things I wanted to ask you, Harold, as somebody who spends a lot of time with the regime. One question was you indicated that the parties at some point had decided that ocean iron fertilization simply wasn't effective, right? And I was wondering where in the record that had happened or what the procedure for that was. And if the parties decided that it's not effective per se, right? Why is it included at all in the protocol? And why is it not just been officially prohibited as a potential activity under London?
This is, I mean, I would think that the contracting parties were of the view that there's no the understanding was it will probably not be effective concerning climate mitigation, but there was also an understanding it is not reasonable to stop research. So this was the understanding was let do the researcher do their work, and if they come up with convincing arguments and scientific results that ocean fertilization may help, then it's fine. So this was there was no I mean you're asking me for the reasons of this balanced regulation, and I think that were the reasons.
Okay. And then the other question is, one of the trepidations that we see right now in the marine startup community is an idea that if these other approaches, ocean alkalinity enhancement and any kind of biomass sinking, is placed under the rubric of the protocol and the convention in the same guise as ocean iron fertilization was, which would limit it to legitimate scientific research at this point and risk assessment, that it's a runway to nowhere, right? It will not ultimately ever permit deployment, right? Do you think that it would be possible and it would be helpful if the convention parties were to outline some criteria by which we could move potentially from the permission to conduct scientific research to the point of deployment, some metrics or some kind of guidelines? Because I think that's one of the major concerns is that investors are going to say, well, this convention says you can do research, but it's never going to allow us to do anything else, and it doesn't have any standards to ever get us to that next step. Do you think it would be possible and helpful to develop such standards?
How to answer this question correctly? I mean, I am. Well, give me a second. I think this in some this no I answer this differently concerning ocean fertilization. The two resolutions and the amendment of 2013 sent the signal that there should be no deployment, and this is you can't deny it. It's sort of a disincentive for private investments. So this is, I think this is the starting point, and maybe we there's a need to think about this effect, because although I would not say it's appropriate to decide right now that deployment could take place, investment in research is a reasonable thing. So this is also private investment in research is a reasonable thing. And so we need to there's a need to think about this challenge. I do not have the answer, and maybe what you have raised one mechanism to outline the criteria which needs to be fulfilled in order to move from research to deployment. This may be one mechanism, but there may be also others. So this is I think we need to think about this a bit more in depth, but this is certainly a mechanism which should be considered. But if you talked about the criteria to move from research to deployment, for me the core criteria is not the protection of the environment. The core criteria to start deployment is the evidence that the techniques are climate effective. This is the core criteria. This must be evidenced, in my view.
But does that track what the resolution says or what the London Convention says? Because it is my understanding that the
No. I did not say that. I did not say this is I described the legal regulatory approach for the time being, but we need to, I said we need to consider this question, this
Right.
challenge of enabling and allowing, incentivizing private investments. I mean, or at least not disincentivizing private investments. And we need also to there's a need to start thinking, what are the criteria to allow deployment? Of course, we need that discussion. I don't need this discussion, yeah. But it's not yet undertaken, so we need to, but maybe such a forum like here could talk about this and could come up with ideas, and then this could be part also for the national policies, and then it could get to the international level. Yeah.
Right. But ultimately the criteria wouldn't just be whether it's effective, right? You would still have to weigh that against the potential risks to the environment, correct?
Yeah. And I'm stressing this point of climate effectiveness because I think it's the starting point. If there's no evidence that it's climate effective, we do not need to think about the risk, because then we can just stop the talk on this technique. If it's not climate effective, we do not need it. I mean, this is.
Yeah. Roman?
Can I ask, Will, what you mean, Howard, when you say climate effective? I mean, if there were a technique that was shown to not necessarily mitigate climate change itself, but to address some of the adverse impacts of climate change, like ocean acidification, like that may be a reason for moving ahead. It seems to me that, like, depending on how you define climate effective, that could actually be a very narrow standard and could really limit the activities that you might want to move ahead with for a variety of other reasons.
Yeah, I mean, you're putting me a lot on the spot right now, because this is the $1 million question actually. But this is quite complicated. I mean, we know that certain SIM techniques are not really helpful with regard to climate mitigation, but they might be helpful with regard to ocean protection or to climate adaptation. So there might be also other criteria to allow techniques to go forward. But I mean, the first thing, there must be, in broader terms, we need evidence that there is a benefit concerning ocean protection or climate adaptation or climate mitigation. This must be evidence. This is the starting point. I mean, and if you talk about this, I mean, you can also, this is also a very complex issue. If you talk about climate mitigation, you can only calculate the reduced emissions. all the captured emission, but you need also to take into account the effects on biodiversity by this technique, because if there's an effect on the biodiversity, this has also again an effect on climate change. So and I mean, for us as lawyers, it's quite easy to say you should consider all these dimensions, but you need technical standards for that. You need methodology for that, and you need agreed concepts. So if you look at the assessment of certain hazardous chemicals, it's such a complicated process, and to think about the efficiency of a marine geoengineering techniques, it's probably a bit more complicated than the assessment of chemicals.
Can I ask one more question, Will? Do we have time?
Yeah, we've got time.
Harold, I'm sorry to keep putting you on the spot, but I did have a question about, obviously, as you said, this is a hugely complex topic with lots of sort of competing factors and this need for all this balancing. But we know that we need some international governance in this space because these activities have global dimensions. I wanted to ask you about the timing. You laid out in your presentation this long history of activity under the London Convention and Protocol. But really, we have a lot of statements and resolutions to show for it. But beyond that, we don't have all that much to show for it. The amendment hasn't entered into force. I think there's still a lot of questions about how we actually move to a regime that's sort of binding in a period of time that's appropriate given the climate crisis. So I wonder if you have any reflections on the slow movement under the LCLP. Not for lack of work. I know that there has been a huge amount of work and effort that's gone in.
We have seen that, the amendment of 2013 has been adopted unanimously. So all the delegations said yes to this amendment 2013. Interesting political factor aspect. But then we have up to now only 6 to 7 ratifications. So we need to think about the reason. Could you interpret that the amendment of 2013 is not any longer supported by the contracting parties? I would say no. We transposed the amendment into national law. It took us 2 years. It's a lot of resource. It's a lot of time. It's a lot of energy. Although the transposition in our national context was not at all controversial. It was just to deal with all the formalities. And I think my assumption why there have been only such a low number of ratification is just because most countries, there is no internal interest. Why should Saudi Arabia spend all this time and resource to ratify the 2013 amendment, although they do not have any research institute doing MGE technique, doing MGE research? There's no internal need to ratify. Same goes for Zambia, same goes for Kenya, it's only a few countries, and most European countries of the global north, which are in a situation where there are research ongoing, and therefore they need this international agreement. I think that's the reason. Unfortunately, Same goes actually also for the 2009 amendment concerning the lifting of the ban of it's actually only required mostly required for the European countries, because there is a cooperation concerning carbon capture and storage in the oceans. There's no need for African countries because they don't do that. And therefore there is no need for cooperation and transboundary movement of CO2 to sequester in the ocean. So, but that does not mean that there's no support for this amendment and for these regulatory approaches. You need to differentiate that.
All right, that is a good point to end on. We are at time, and so I'd like to once again thank Sina and Romani and Harold for their excellent presentations, and then our questions. And this is invariably an issue we'll return back to. And I thank everybody for their participation. So we're now going to take a 10-minute break, and then we'll come back for our final panel, which will focus on public engagement issues and drill down a bit more on some of the issues that Romany discussed, looking at some case studies and some potential implications of how to extend public engagement, some in the ocean context, but with broader implications, including for terrestrial CDR. So I hope everybody can join us, and we will see you in 10 minutes. Thank you.